Hello, this is Lynn Bergeson. As many of our listeners may know, we here at Bergeson Campbell recently published a book through the American Bar Association Environment, Energy, and Resources section titled Chemical Product Law and Supply Chain Stewardship, A Guide to New TSCA. Recently, my American Bar Association colleague, Amy Edwards, a partner with Holland Knight, and I recorded a podcast to discuss the book, why we here at Bergeson Campbell wrote it, and why chemical stakeholders of all sorts, most particularly business people, non-TSCA experts, and professionals engaged in due diligence and commercial transactions should read the book. The podcast was a lot of fun and a great listen. I hope you enjoyed the podcast and, of course, read our book.
Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
Hello, I am Amy L. Edwards, an environmental partner with Holland Knight in Washington, D.C., and I'm very pleased to be talking today with Lynn L. Bergeson about her new book, Chemical Product Law and Supply Chain Stewardship, A Guide to New TSCA. This is not Lynn's first book about the new TSCA. She co-authored another book published by ABA section of Environment, Energy, and Resources called New TSCA, A Guide to the Lautenberg Chemical Safety Act and its Implementation, shortly after passage of the Frank R. Lautenberg Chemical Safety for the 21st Century Act. For those who do not know Lynn, she is a managing partner of Bergeson Campbell, a firm that specializes in issues arising under TSCA, FIPRA, EU REACH, and the Food Quality Protection Act. Lynn is a past chair of the section of Environment, Energy, and Resources, immediate past chair of the International Bar Association's Agriculture and Food section, and current advisory council member, and a fellow in the American College of Environmental Lawyers. Lynn has published scores of articles and books on legal, regulatory, business and science policy issues, and has hosted a podcast called All Things Chemical since 2018. Lynn, thanks for taking the time today to talk with us about your new book.
Well, thank you, Amy. It's a pleasure to be here. Thank you for having me.
We wanted to start with a question about your firm and the scholarship in this field. Your firm has published a lot of scholarship and commentary on the Toxic Substances Control Act, including a 1,000-page book called Guide to the Toxic Substances Control Act, updated annually and published by LexisNexis. What motivated you to write this new book with the American Bar Association, and how does it differ, say, from the Guide to TSCA?
Good question, Amy. And I think what the primary motivation was when we did the first book on TSCA, it was immediately after the 2016 amendments to TSCA were implemented. What has happened over the past 9 years is EPA has implemented the law in strange and sometimes inconsistent ways, given the 3 different presidential administrations that have been in power since. So our new book is intended to reflect this implementation and intended to decode what TSCA means in business terms and reflect the lessons learned over the past 9 years. To our eye, there's no other book on the market like it, and we really try hard to present TSCA through the lens of a business person.
That is so key. Some of our listeners might regard chemical compliance matters and chemical regulatory matters to be the responsibility of the regulatory lawyers or environmental health and safety officers. Why should a chief executive officer, investor, or other non-practicing lawyers spend time thinking about TSCA?
Well, that's another good question, Amy. Sometimes I have a hard time convincing people of the wisdom of that statement, but understanding at a very high level the new commercial rules of engagement that TSCA has ushered in, to me, is essential to be competitive and compliant. TSCA may not be top of mind for many chief compliance officers, let alone CEOs, but because TSCA is so commercially consequential in terms of market access, import restrictions, employee and worker protection requirements, and other commercial terms, to me, every CEO, financial investor, and other stakeholder working in the manufacturing sector should have at least a baseline understanding of how TSCA works.
That is so true. We've certainly seen that in our transactions. Are there legal practitioners whose practice is not TSCA? How is this book useful to them?
Well, in my view, yes. Our goal was to write a book that is accessible to lawyers and non-lawyers alike. And for all the lawyers listening on this podcast that think TSCA is this wonderful restaurant on F Street in Washington or, or a Puccini opera, we would urge you to think again. TSCA is all about market access. It is about deselecting chemicals that might invite risk and engineering products that are sustainable and marketable in as many geographic markets as possible, and thinking strategically to avoid restrictions that could put your company and its officers at a competitive disadvantage. So M&A lawyers, corporate counsel, trade lawyers, communications departments, and business counsel of all stripes really should have a general knowledge of TSCA's reach into the business community.
Let's talk a little bit about the new reach of TSCA. Is this newly expansive jurisdictional reach of TSCA primarily affecting newer chemicals and product developments?
In my view, and TSCA aficionados may differ on this, but the 2016 amendments to TSCA have definitely slowed new chemical innovation in chemical technologies and have made it, in our view anyway, much more challenging to innovate new chemistries in the United States. But existing chemicals are very much a part of the mix as well. As you know from your practice, chemicals that have been targeted as like high priority, and there are maybe 38 to 40 of them now by EPA, are consequentially very reviewed and thought differently in the commercial terms. This is a subject that we speak a lot about in Chapter 4 of the book. Once something is considered high priority, as the name suggests, it sets into motion a series of inferences, market impacts, and supply chain implications that business people can't ignore, or if they do so at their jeopardy, and should be managed proactively and strategically.
Great. Can you give me an example of how TSCA might affect a person who we do not think of as holding a chemical regulatory role? Let's say I am responsible for purchasing a manufacturer of consumer goods. How does TSCA affect my ability to make good decisions for my company?
Over the past 9 years and even before, we have found that people in the acquisitions departments of companies hold a very strategically important role. It is not uncommon, for example, for an acquisitions department to locate alternative chemical suppliers that may or may not be TSCA compliant. Suppliers of components to product formulations change, or they may discontinue a particular ingredient for any number of reasons, and a replacement needs to be identified. In those instances, a company's purchasing agent may switch to a different supplier for cost reasons, for example. If a replacement chemical or component or product is not TSCA compliant, there are all kinds of very impactful commercial consequences that follow from that. Penalties can be applied, I think it's around $39,000 a pop now. Cessation of product activities might be warranted. Imports might need to be stopped. Recalls might need to be considered. The level of commercial disruption, reputational injury, legal cost, and just the distraction that these types of decisions invite are perhaps disproportionate to the role that a person might think they occupy in the supply chain for their companies. Every employee is really in need of knowing how their decisions, their day-to-day decision-making process, might invite an adverse consequence under TSCA. So acquisitions is a super important role. R&D, supply chain managers, product stewardship managers are all very much a part of the TSCA picture and need a baseline understanding of their role in this supply chain.
That is so true. We're going through one such incident with a client right now where there's a combination of FIPRA and potential TSCA regulation. And it is kind of that the supply chain folks don't fully understand sometimes. Your book has a chapter on transactions such as acquisitions and divestitures. One of your co-authors asserts that TSCA compliance is an integral component of due diligence in commercial transactions. Can you give us a couple examples of the types of TSCA issues that might come up in a typical commercial transaction?
Sure, and I'm sure in your practice too, Amy, this is often an issue. TSCA reporting records or the absence thereof is a big tell. If you ask for all the chemical data reporting documents that have been submitted to CDX, Section 12 and 13 import-export records, an inability to confirm that all chemicals that are pertinent to a manufacturing operation are TSCA compliant is a tell. Confirmation that all chemicals are either listed on the TSCA inventory or exempt from listing is important. I write articles for a British publication called Financier Worldwide. It's a business journal, and we have been, over the years, kind of really harping on the need to be mindful of TSCA implications in due diligence, because to my infinite surprise, there often is no TSCA kind of component for due diligence. It surprises me. It is getting better, but historically, it has been an underserved area in corporate due diligence and mergers and acquisitions.
I think we could do a separate podcast on that topic alone, simply because I think all due diligence is too focused on circular liability,
Exactly.
not on climate change issues, not on TSCA,
That is
but
so
for a
true.
separate podcast. Can you give me a couple of examples of red flag issues that might come up as part of an acquisition or divestiture?
Sure. Yeah, I think, like as noted, a big one is, what's in the data room? Is anything pertinent to TSCA? Is it utterly devoid of TSCA records? If we ask for TSCA SOPs, are we getting anything back? Are we asking for, as I said, confirmation that chemicals are on the inventory or exempt, and why are they exempt? If you get a question back like, well, what inventory? What are you talking about? That's a red flag. Other red flags could depend on what is known about the chemicals, but in the most serious of cases would involve instances of potential noncompliance that have been identified that could either really compromise production operations or just kill the deal. I'm sure you've experienced that. We've recommended that based on a complete avoidance of TSCA for the past 40 years, you're looking at some pretty big compliance cost. And if the deal is not up to snuff in terms of supporting the cost of that newly identified obligation, the deal could be off.
So true. Drilling down a little deeper, can you explain the potential significance of substances regulated or proposed to be regulated under TSCA sections 5 or 6?
Sure. At a very general level, when a substance is regulated or proposed to be regulated under Section 5, which relates to new chemicals, not yet commercially available, or Section 6, existing chemicals, it kind of bottom line means that EPA has identified a concern regarding that substance's potential adverse effect on human health and or the environment. So based on those concerns, whether you agree or not with EPA has identified something, so there's a red flag. EPA is usually seeking or has already issued a rule that restricts or bans the ways in which a substance can be manufactured, imported, processed, or used. Now, as you know, Amy, well, these restrictions vary significantly, but could limit the amount that is either imported or manufactured of a key raw material. It could limit the way the chemicals are manufactured in the workplace. It could limit the market or access to markets, like no consumer product or industrial use only. And it can restrict the way in which a substance can be manufactured or formulated in the manufacturing operation. For example, there might be no release to water. Understanding what these limitations are is critically important because it will have a very important role in your bottom line, your compliance cost, how your employees might need to be protected from workplace exposures. Personal protective clothing and equipment considerations are always important in explaining to employees why you're now wearing half-face respirators when you might not have been previously. Potential resulting significance is that an EPA proposed or final rule will affect the way that you manufacture, import, or process a chemical or a product, and thus impact the bottom line. And even if a particular rule does not specifically affect your process or your product line, there might be other requirements imposed on anyone manufacturing, importing, or processing the substance, including export notification requirements or notifications to downstream customers, which, oh, don't get me started. These communications to downstream customers is super important and often overlooked or not given the attention they deserve. As you know well, Amy, how you present a commercial restriction to a member of your supply chain needs to be handled with care, transparency, and a good deal of diplomacy, right? Because you want to put your best foot forward, but also explain why a particular element in your product is now requiring additional government scrutiny. So these Section 5, Section 6 restrictions are very much on the rise and very important in managing and very important in communicating up and down the supply chain.
So true. Can you talk a little bit about TSCA Section 8 chemical data reporting?
We look at Section 8 data reporting as important because EPA regards this quadrennial, once every 4-year reporting obligation for a number of reasons. EPA relies very extensively on the data elicited by chemical manufacturers and importers of chemicals. It requires that you report certain categories of information, how much you are manufacturing or importing, what type of chemical it is, what types of markets are you serving, what type of exposures might you be aware of. So it's important as a data gathering element for EPA, and EPA often relies upon chemical data reporting data for purposes of prioritizing its next round of chemicals to consider for review. It's also important because, in our view anyway, it's a very easy target for noncompliance. The agency has developed a number of very sophisticated enforcement algorithms to assess whether your reporting is similar to what it was the last reporting cycle, and if there are material differences or you didn't submit at all. It's a very big opportunity for enforcement. And as noted, these penalties are expensive, they rack up, and can invite both costs transactionally in terms of retaining legal counsel to defend yourself, just investigate the allegation of noncompliance, and deal with the fallout of having a press release indicating that you violated TSCA. Now, it's one of those fish in a barrel opportunities for enforcement, but the data themselves are very helpful for EPA and relied upon for prioritizing chemicals for additional review and regulation.
Oh, so key. And I know we touched upon this a bit, but could you talk a little bit more about potential market access issues, product recalls, and reputational risk?
Sure. And I want to be positive here because I've been working in the TSCA space for over 3 decades. And, once upon a time, TSCA was thought to be a quirky, pretty discreet, oh, that's the statute that only chemical manufacturers have to worry about. But since Lautenberg was enacted almost 9 years ago, will be June 22nd, 9 years in running, I think there's growing recognition that TSCA is very much a financial statute. It does really impact a manufacturer, chemical manufacturers or product manufacturers' access to markets because of restrictions EPA increasingly is imposing on new and existing chemicals. So understanding how the 2016 amendments have been implemented has been a priority for institutional investors, private equity sources, banks, and others that are much more cognizant of how TSCA restrictions can be barriers to trade, barriers to business, barriers to access, and how understanding what these conditions are and trying to limit their application, but if they've already been applied in a rule whether it's an existing chemical rule like the risk management rules that are coming out now, or significant new use restrictions on new chemicals or existing chemicals. Understanding what those barriers are the key to being competitive and, of course, TSCA compliant. It's still kind of an underserved area, but I think the financial markets and business people writ large are much more cognizant of how these tools can result in, to your question, Amy, product recalls, plant shutdowns. These are usually voluntary, by the way. It's not that EPA will come in and shut a plant down, but if you are manufacturing a product that is not TSCA compliant, you either seek EPA's enforcement discretion to continue or take measures to get into compliance, which often requires that chemicals be embargoed or red tagged and not used until that instance of noncompliance is remedied, which is never quick or easy. It's really slow and it's really costly. Right, exactly right.
If doing due diligence, we discover non-compliance issues, are there things that a buyer and its counsel can do to mitigate the risk?
Sure, and I know, Amy, you and I could do a separate podcast on this topic too. They're the usual array of standard contract remedies, indemnification, holding money in reserve, reps and warranties, and all the things that smart lawyers do to protect their client from risk. But in the TSCA area, there are a couple of other features of which, listeners should be aware. We devote an entire chapter in the book to these types of situations and include in our appendices TSCA and commercial transactions, what to look for, and provide a list of things to do and not do. EPA has been especially, I think, mindful and supportive of entities engaging in due diligence of one form or another and offering opportunities to voluntarily disclose instances of noncompliance. You don't have to be in a due diligence to avail yourself of EPA's voluntary audit policy. If you are engaging in an exercise of self-review for compliance and find some indiscretions, for lack of a better word, you can tell EPA about those indiscretions, and if you meet the 9 criteria that are carefully laid out in our book, you can perhaps mitigate up to 100% of a penalty. If not all 9, but most, and I think 8 of the 9 are satisfied. You can mitigate penalties up to 70%, depending upon, again, the facts and circumstances of the disclosure. So this is EPA's way of saying, look, if you find you messed up, we're going to reward good behavior if you tell us about it and take prompt remedial steps to fix the problem and get on the road to redemption here. There's another policy that EPA has issued allowing new owners of facilities to kind of wipe the slate clean. Again, facts and circumstances are important, but if you meet the criteria, the agency will reward entities that appreciate that a new acquisition is not up to snuff from a TSCA compliance perspective. And working with the agency, you can mitigate penalties and have the comfort that the new operations that you are pursuing as a result of a deal or an acquisition are fully compliant and not worry about fines and penalties. Again, reading the policies are important, satisfying the conditions are important, but it's a very big incentive to being cooperative with the agency, disclosing issues of noncompliance, and engaging in prompt remedial measures to fix them. I will hasten to add, Amy, as I'm sure you would if you were asked this question, ratting yourself out is not a legal requirement. It is an opportunity to, and EPA has incentivized that type of voluntary disclosure. But you're not legally required to self-confess. You are legally required to remedy and comply with the law once it has been found to be in an area of noncompliance, because failure to do that can get you really into hot water on the knowing and willful front.
So true. I want to switch gears a little bit and talk about articles under TSCA. This is one example of the broader reach of the new TSCA. So could you give us a little bit more information about what an article is and why lawyers doing due diligence need to understand this new broader reach of TSCA?
You correctly noted, Amy, that this is a big switch from the first 40 years of TSCA from 1976 to 2016, where articles, as that term is defined and as I'm about to explain, were largely exempt from TSCA, always covered by TSCA, but often backed out of it. But an article is just a fancy way of saying a manufactured item. And then the agency identifies a couple of factors that help further refine what that means. So it's a manufactured item that has a physical shape or design that is related to its function and that undergoes no chemical changes not related to its end use. So substances that are intended to be released from an article are not part of the article. Now, let me give a couple of examples here because I know this is an area that invites significant confusion. A pen, a handwriting pen, is an article. Substances that make up the casing of the pen are eligible for the TSCA article exemption. But the ink in the pen is a mixture of substances that are not eligible for the article exemption because the ink is intended to be released from the pen while you're, using it. Another example is a car. A car is an article. And whether the fluids in the car are eligible for the article exemption depends upon the function of the fluid. So in EPA's view, the transmission fluid in a car is part of the article because it is not intended to be released. But the windshield washer fluid in a car is intended to be released. It's sprayed on the windshield, for example, serving its intended purpose, and is not exempt.
That's such a great example.
Well, it has invited an awful lot of confusion. And there are some good resources that EPA has made available on this subject. EPA's chemical data reporting guidance provides, I think, some really good examples, as does EPA's new chemicals Q&A. You just go to Google or the EPA website. I think you can go to the EPA website. It's changed a lot, as you know. And just search for Q&A for new chemicals and CDR guidance on articles. And the agency has really historically done a good job of trying to define what is in and out of the article exemption.
And you also mentioned TSCA standard operating procedures before. Could you elaborate a little on what those are?
Well, I use the term SOPs to refer to documents that we have prepared and perfected over the years for key TSCA provisions. Whether we prepare them or companies prepare them or extraordinarily brilliant law firms like your law firm, Amy, prepare them, it doesn't matter. But it is important to have a written document that sets forth policies and the procedures and the how-tos of the core elements of TSCA, Section 4 testing, Section 5 new chem, Section 6 existing, and perhaps most importantly, Section 8 record keeping and reporting. They are very helpful in identifying the policies and procedures that will ensure that you are compliant or achieve compliance consistently. And to me, they're even important for entities that aren't traditionally thought to be subject to TSCA, like furniture importers. EP could allege noncompliance if a sofa were imported with long-chain PFAS surface treatment on the fabric or decarbromo-diphenyl ether flame retardant in the cushions. Even if you don't really think you're part of a broader TSCA entity to which the regulations apply, chances are you are, and having a standard operating procedure that consistently defines how you respond to TSCA and comply with it will serve your commercial interests well, and it provides EPA inspectors and potential investors and potential partners in due diligence the comfort that you know what you're doing and you were smart enough to prepare an SOP to guide your activities as you exist as a commercial entity. That's our philosophy. I'm sure you guys have a similar take on that.
That's great advice. I think that's very practical and informative and helpful. You've been practicing in this field for more than 30 years, and your firm has professionals who are PhD scientists and veterans of regulatory agencies. Do you think a business person who does not have that kind of legal or scientific background can really understand enough about TSCA to be able to make decisions informed by TSCA?
Well, yes, absolutely. I mean, it is true we have a bunch of non-lawyer professionals on the team here, but you don't have to be a PhD chemist. And our book, our like 200-page book, was really intended to demystify TSCA so it stops being this abstraction that has little relevance to the real world. It really is intended to enable readers to acquire a baseline understanding of TSCA to help manage commercial risk, avoid enforcement, and point companies in the direction of more sustainable products.
Your book contains a chapter on TSCA and PFAS. What are the highlights there?
Unless you've been living on Mars or in a cave, you know that PFAS is kind of ruining the roost right now in a big way. But for TSCA purposes, a fast approaching one-time reporting obligation is on the horizon. This is TSCA Section 8A7. The reporting deadline is coming up July the 11th of this year and ends on January 11th of next year. It requires reporting for a very long look-back period of any PFAS broadly defined by EPA that you have manufactured or imported in any year between 2011 and 2022 inclusive. So it's like a 12-year period. And and this is the real kicker here, unlike other TSCA Section 8 reporting rules, this rule contains no exemptions for byproducts, impurities, small quantities, articles to our discussion earlier. So anything that you've imported or manufactured that contains a PFAS, as defined by EPA, is required to be reported. So it's an enormously important rule, not just because there are compliance implications, but much of the information that is not asserted to be CBI will be made publicly available. So given the intense interest from commercial and litigation perspectives, PFAS is inviting these days, or PFAS are inviting these days. This reporting obligation is important. And I hasten to always add, because EPA kind of takes a hit on it, this is not EPA's rule. This was a congressional amendment that Congress wanted to disclose PFAS in commercial settings going back this long 12-year reporting period. But EPA chose not to exempt any PFAS as it would have provided under other TSCA reporting obligations. So it's quite onerous, it's a big deal, and I think a lot of people are speculating on whether the new administration will push back the reporting deadline starting in July or provide exemptions to the reporting requirements. So your guess is as good as mine, Amy. I don't know if you have a thought or two on that.
I think this will be an interesting one to follow, having tried to help at least one client getting through this 8A7 reporting considerations. I think the related question that we should touch on is that importers are treated as manufacturers. Do you want to talk a little bit about that?
Yes, I know because I've been working the TSCA beat for so long, I neglect to add that under TSCA, if you are an importer of a chemical that EPA has expressed interest in, you are a de facto manufacturer of that product. So you stand in the shoes of the entity that domestically is producing it. So the TSCA 8A7 has commercial implications for certainly domestic entities importing, but also it has invited a very robust discussion between and among supply chain members. And our book, Chemical Product Law and Supply Chain Stewardship, is intended to reflect how important supply chain communications are these days. Entities that are importing product are under the standard of due diligence that applies under 8A7 are really urged, if not required, in my view, to inquire of their offshore producers and suppliers whether the product contains a PFAS as defined under the EPA's working definition. It's an illustration of just how remarkably different the commercial world is now since the 2016 amendments. Getting much more communication going between and among suppliers and supply chain partners is essential to doing business under TSCA. And the 8A7 reporting rule, because it applies to the import of chemical substances, including chemicals in articles, makes it all the more important that people appreciate just the size, the magnitude, and the burden this 8A7 reporting obligation is imposing on just about everybody in the supply chain. And I know you've probably been super busy with this, as we have, Amy, in addition to the emerging state PFAS restrictions that are even more restringent, significantly more restringent than the 8A federal reporting obligation under TSCA.
It is a brave new world. Any other parting thoughts?
You can buy the book, Chemical Product Law and Supply Chain Stewardship, at the ABA bookstore. Amazon offers it. Our website does. I think we wrote the book for an easy read, one that is calibrated to resonate with business people who are not lawyers. So my advice is buy the book, grab it before the Memorial Day weekend, because it's a great beach read.
It actually is very practical, so that is an appropriate plug. Thank you very much for this very informative and thought-provoking discussion, and I do hope that everyone takes up your advice and purchases the book and understands how this really should affect their due diligence, among other things. And we appreciate you sharing your wisdom with us.
Oh, my pleasure, Amy. Thanks for the conversation. I enjoyed it.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/Envira. Please check where you found us for future episodes. Thank you for listening.